I'm going to take this from Ohio Guardian as an actual question, wanting an actual answer. He wants to know, is it possible that the SCOTUS opinion on the issue has already been made clear in a previous decision like the one cited above? No. No. And there's good reasons why. This is the First Amendment. Congress, etc., or abridging the freedom of speech or the press or the right of the people to peaceably to assemble and to petition the government for a redress of grievances. The case law surrounding the First Amendment is entirely different than the case law surrounding the Fourth Amendment. The case law surrounding the First Amendment says the government can't stop a person from exercising their freedom of speech, which filming is, without meeting the various requirements and the various tests based on how the government is attempting to regulate that speech. The Fourth Amendment is entirely different. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, that is understood to be by the government, shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, particularly describing the place to be searched and the persons to be seized. So, when you're doing a constitutional analysis of a Fourth Amendment search, you're not going to be worried about the expressive conduct of a person. You're going to be worried about the search of the government. Expressive conduct of a citizen, search by the government. There is zero overlap there. Let's look at the case. This is McDonald v. United States. In McDonald v. United States, all right, so let's look at the background. There are a couple guys running a numbers racket, like a gambling deal, out of a boarding house. The police got suspicious because one of the guys who owned a home, and he would go to this boarding house where he rented a room, and he would conduct his business there, and police officers were staking it out, and they could hear an adding machine going, because apparently adding machines were super loud back in the late 40s. So instead of getting an evidence, in fact, they didn't have probable cause to get a warrant. Instead of getting a warrant, they decided to break into this boarding house. They climbed. One of them climbed through the window of the landlady's room, explained the situation, opened up the front door. Well, he identified himself as a cop. It doesn't appear that he ever got her permission. Opened up the front door for the other cops to come in. They all went up to the doorway to the room that the two men were in, doing their numbers game. A transom is basically like a window over the door, if I understand correctly. And so they got a chair and they looked over the transom into the room, and they could see these guys engaged in running a numbers racket or whatever the hell it is. So with that understood, all right, this is the prosecution's argument right here. This is the prosecution's argument as to why the police weren't violating the Fourth Amendment rights of Mr. McDonald and Mr. Washington. There's no expressive activity. This is the prosecution's argument as to why the Fourth Amendment rights of Mr. McDonald and Mr. Washington weren't violated. So it says the prosecution seeks to build the lawfulness of the search on the lawfulness of the arrest, and so justify the search and seizure without a warrant. The reasoning runs as follows. Although it was an invasion of privacy for the officers to enter Mrs. Terry's room, that was a trespass which violated her rights under the Fourth Amendment, not McDonald's. Therefore, so far as he was concerned, the officers were lawfully in the hallway, as much so as if Mrs. Terry had admitted them. Looking over the transom was not a search, for the eye cannot commit the trespass condemned by the Fourth Amendment. Since the officers observed MacDonald in the act of committing the offense, they were under a duty then and there to arrest him. The arrest being valid, the search incident thereto was lawful. So, if you completely misconstrue and misunderstand what they are saying when they say trespass there, then it sounds open and shut. But if you keep reading, he says, we do not stop to examine the syllogism for flaws. Assuming its correctness, we reject the result. So they're not saying that is correct. They're not saying that's correct. They're saying the result is incorrect, but they don't even stop to examine the syllogism for flaws. They're not even saying that statement is correct. They're saying that we don't even care. We'll just assume it's correct and we still reject it. So, at the end of the day, that's one of the many reasons why it's not applicable at all to what you're trying to make it out to be. They're using the term trespass differently than a actual physical trespass violation of a criminal trespass statute. They are using, this case is a Fourth Amendment case, not a First Amendment case. It's a Fourth Amendment case. And finally, the language cited was the prosecution's argument that the court didn't even deal with. It just said, assuming it's correct, we reject the result. So there is nothing there for you, OG2. There's nothing there for you. It is not what you want it to be. The eyes, the eyes can commit trespasses, meaning the eyes can commit offenses. Peeping Tom statutes. The California Peeping Tom statute is, I think, 647. How about you did it this way? Leginfo. Penis code. And we want 647. Search. And it should be J. The person who looks through a hole or opening into, or otherwise views by means of any instrumentality, including but not limited to, etc., the interior of a bedroom, bathroom, changing room, fitting room, dressing room, or tanning booth, or the interior of any other area in which the occupant has a reasonable expectation of privacy with the intent to invade the privacy of a person or persons inside. That is a misdemeanor. And it says, you have to read it carefully, but it's, if you just look through an opening, if you just peek through an opening, like into a changing room or something, because it's or by any means of any instrumentality, etc. So yes, you can get charged with this just for peeking into a changing room or someplace where the occupant has a reasonable expectation of privacy, because it would be an invasion of privacy, etc., etc. And yes, they could also probably sue you for the tort of invasion of privacy. So yes, I hope that explains it. The trespass in this situation would be that you are invading someone's privacy. But again, I'm using the trespass in the term of the offense. Anyway, thank you for watching. I hope that answers your question, OG2, and have a great day.